Well, good afternoon, everybody. Thanks for spending some time with Ellen and I this afternoon as we think about some of the important issues you all need to be thinking about this spring and heading into this summer as it relates to school law. My name is Brandon Wright. I'm joined by my colleague Ellen Lueking today. So we're going to talk through several things today, but as promised in our advertisement, we're going to spend the first half, roughly, of our conversation talking about the new Title IX regulations and what we need to be thinking about to get ready for that implementation. And then we'll kind of walk through a cornucopia of other school law issues that I think are important, some recent Supreme Court decisions and other things that need to be on your radar as we plan for next school year. As always, feel free to ask questions through the Q&A feature. So we've got the Q&A feature up. So don't be shy about asking questions if you have any as we go along. But I say we jump right in. Ellen, how about you?
I am in favor of jumping right in.
Well, I'm going to maybe let you do most of the heavy lifting as we think through these Title IX regulations. I know we've been anticipating and talking about they're coming, they're coming, they're coming. When are they going to be here? And now they're here.
Yeah.
So these are some, we want to run through some of the key points that you need to be thinking about for planning for next school year.
Okay. So here were the big issues that we saw under the prior rules. There was a lack of training. There was a lack of even knowledge that Title IX existed, and it was subject to separate grievance procedures than normal student discipline issues, or normal investigation issues if it was employee related. And a lot of times, administrators were trying to learn how to swim when they had been thrown into the ocean, into the middle of the ocean, and they were just drowning. So what we would encourage here is that we avoid that problem by getting ahead of it and getting your training done this summer. Catherine Lehman, the Assistant Secretary for the Department of Education, has made it pretty clear that there's not going to be a lot of grace for districts that don't get ahead of these new Title IX regulations. We've known about them since April 19th, and we know that they're going to be effective on August 1st. So there is plenty of time to get our administrators trained over the course of this summer, which I think probably leads Brandon and I to telling you that we are working on what we are going to do regarding our training over the summer. We just sat down earlier this morning, late morning, and discussed that I think we're probably going to do some sort of tiered training. Both of us have already been contacted to get in front of some school districts, in front of some ROEs this summer. We're happy to do any of that. So reach out to us directly if you want to schedule something like that. We're also planning to record some training and have that available on demand if us coming to your district isn't going to work for you.
Yeah, and I think just again, before we get into the nuts and bolts of the actual changes in the regulations, the current regs, the 2020 regs, as well as the 2024 regs are very specific when it comes to the training requirements. And I think that what happened in a lot of districts is that maybe we undertrained the number of people who needed to have that training.
Yeah.
And these new regs expand the people who have to be trained in different ways. And so I want to make sure we're not waiting until we actually have something that might be Title IX to be trained. Because one of the issues that I've seen with that, and I suspect you have as well, I know you have, as we've talked about it, Ellen, is that sometimes people aren't able to spot when they're in Title IX territory because they haven't been trained. And so I think having your principals and assistant principals, especially trained on Title IX, is going to be really
And if you
important.
have deans of students, I also think they're great people. They're going to be required to be trained on the most basic level of recognizing what sex discrimination is under these new rules. But I also think they're great people to have a little bit more in the know as to the investigator component, because those are oftentimes the people who are first contact with kids.
Yeah. And so, and as Ellen said, I know many of you that I see on today, we've already scheduled some training with you in your districts or through your ROEs. We'll continue to schedule those, as well as we'll likely make our training available sometime midsummer as our hope. So We want everybody to be trained by August 1st and have that opportunity to do so. So that's our plan when it comes to training.
Mhm.
You want to talk about website compliance too, Ellen?
Yeah, that's an issue that we've seen with the under the prior rules, is that districts' policies and procedures aren't prominently displayed, and sometimes their procedures aren't displayed at all. The prior rules did require that those procedures be displayed. For most of our districts who use press, that's going to be an administrative procedure, and I would say none of our districts, as far as I'm aware, post those procedures on their website. So as we move into the new rules, that's still something that we need to be considering is, are your procedures available for your students, your employees, or anyone who might file a complaint?
Yeah, I think that's something that we oftentimes, we have the policy and we have the administrative procedure, but full compliance sometimes is the combination of those two,
Mhm.
and we need to recognize that as well.
Yeah.
But not just those are some of the lagging issues, but we want to dig into how the rules are different. So Ellen,
Yeah.
tell us about these new rules.
Okay, so like I said, April 19th, same day that we got a new Taylor Swift album, we got these great new rules. And I think they are great in a lot of ways. What I'll say is they encompass a ton more conduct than the prior rules did. It was real easy to get things out of Title IX before. Now we're going to see a whole lot more in. So your Title IX coordinators are not going to be less busy, even though we have less procedure under these. They're still going to be running through evaluating case by case whether this incident is Title IX qualifying and what our obligations are through that. These are effective August 1st. Like I said, not a lot of grace for not being ready to implement those immediately. I've been working with IASB, and the current goal is for the new policy and procedures to be available August 1st. So make sure you have that ready to go for your board to adopt, and you have those new procedures downloaded. That said, if we have conduct that occurred under the prior rules, if that conduct occurred prior to August 1st, 2024, and someone waits to complain about it until the next school year, let's say it happened this month and someone first tells us about it August 14th, 2024, you're going to be under the rules that are now effective and your procedure that is now effective. So make sure you have downloaded a copy of 2265 as it currently is, AP1, AP2, and East, and keep those somewhere safe.
Yeah, I think that's a real implementation challenge going forward, is recognizing that for conduct that occurred between 2020 and August 1, 2024, we're gonna have to follow those old rules. So you're still gonna have to have somebody trained on the old rules, in addition to having people trained on the new rules, in order to meet that compliance based upon when that is. Now, as time goes on, we hopefully will see fewer and fewer complaints under the old rules, because we'll see less
Hopefully.
and less about conduct that's alleged to have occurred prior to August 1. But especially this first year, we've got to recognize we may be operating under two rules based upon when the conduct is alleged to have occurred.
Yep. Yep. So we're recommending a tiered training system. This first level is for all staff. They need to have a basic understanding of what sex discrimination is, what sort of conduct would fall under sex discrimination, and what they need to do whenever they hear about something that might be sex discrimination, which means contacting their Title IX coordinator, and in general, the school's obligation to address that sex discrimination, to prevent it from reoccurring, to remedy it to the victim. And so these are the important things for everyone in your district to understand. And this includes those coaches that are not otherwise employed by the school. I think we oftentimes forget about them. Another one that we've had a substantial amount of issues with this year is substitute teachers. So making sure that substitute teachers are also aware of their obligations to report that. For some reason, those coaches that are not otherwise employed in those substitute teachers hear about way more than the rest of your teachers do. And I don't know what that's about.
Yeah, and I think that's an important piece here. Like, and as we think about how we think, tiering this training makes sense, recognize that this is training that the rule specifically requires. So, the prior 2020 rules only really technically required training for those, what we would call Title IX personnel, like your Title IX coordinator and investigators and decision makers. The 2024 rules have components of required training for all staff. And so you're going to recognize that you've got a much broader swath of training you're going to have to cover when it comes to that piece. But you are also still going to have to train those Title IX folks who have those specific roles as well.
Yeah, like your investigators, your decision makers, those who are otherwise involved in the grievance process, including appeals on supportive measures, which is a new part of these regulations, that supportive measure decisions can be appealed. So your investigators, decision makers, and all of these other people that I've just mentioned, they still have to have that basic level of training that all of your staff have to have, but they have to have another layer of training on top of that. Their obligations under 10644, those are going to be your sex-based discrimination complaints and your pregnancy complaints. And then your grievance procedures under 10645, those are your procedures for processing a complaint. And then this is similar to the prior rules: how to serve impartially, how to avoid prejudgment, conflicts of interest, and bias. And then we actually have a definition of relevant in these rules. We didn't have a definition of relevant under the prior rules. I think pretty much everyone agreed that we were just going to use the definition of relevant from the federal rules of evidence. And the definition of relevant now reflects that is essentially the definition that they expected us to use. And we also have to talk about the types of evidence that is permissible and impermissible. So that's going to be your things like medical information or other confidential, like privileged information. Sometimes I had one where marital privilege came into play, which was kind of interesting. So understanding where there is privilege that might exist.
And then on top of that training for those folks, there's also some training for those who might facilitate informal resolution.
And these people are separate from the rest of our people. This might be a great role for a counselor or for your administrators who are very in favor of restorative practices. I think this is a great position to consider for those people. I also think that it doesn't hurt to get everyone trained on this. So they have all of the other ones that we've already discussed, but then they also have information about the school's informal resolution process and how to serve as an informal resolution facilitator impartially. So we have to have all of that impartial, conflict of interest, bias, but coming in as an informal resolution facilitator may bring up some additional concerns.
And then, of course, the person who coordinates it all, Title IX coordinator.
And they have so much more that they have to do. So they have specific responsibilities under 10640, their pregnancy and related conditions. We also have state law coming into play this year, right, Brandon? About a pregnancy coordinator?
By July 1, 2025. So we've got one more year.
We got one more year. Okay.
Yeah, to get all of that in.
It's like we're going to get started a little early under federal law on that.
Yes.
And then we also have oversight on the sex discrimination grievance process and oversight on supportive measures. They have those additional considerations. There are also some things that they have to consider about, are there barriers to reporting sex discrimination? Your Title IX coordinator is also charged with athletics compliance. There are so many more things that a Title IX coordinator themselves has to do. And I do believe we're going to be getting a new administrative procedure under 2265 for Title IX coordinator duties. So be on the lookout for that.
So before we move on to some of the things that are specifically in the rules, I see a training question here that I think is probably something that's on a lot of people's minds. You know, we use Public School Works. There's several of those types of platforms out there that districts use to train staff. Is it acceptable and would it count? And I mean, my knee-jerk reaction is it depends, right? I mean, I think that absolutely for that first tier of training, right? That training that all employees must get, the answer to that is going to be probably as long as it has the right content. You know, your old training, the prior training prior to this year is no longer likely, well, not likely, absolutely won't count because the definitions have changed, right? So it will have to be brand new under the current definitions under the 2024 rules. So Yes, something like that would be appropriate for, I think, your all staff training once it's been updated to include the 2024 definitions and requirements. Thoughts
Mhm.
on that, Ellen?
Yeah, I think you're absolutely correct. And the only thing I'd like to add is sometimes those trainings are so general that it isn't clear about what happens in your district. So you may need to offer a little bit of additional information as to your staff, what you expect of them. So it might say report to your Title IX coordinator, but in that training, it doesn't say who your Title IX coordinator is. And your staff would certainly need to know that that's you.
Yeah, I think that's a really important point. That I certainly have seen not only in some OCR complaints, but in OCR resolution agreements and decisions around the country where that training is lacking because of that key piece, right? Like you train, you're supposed to report it to the Title IX coordinator, but then nobody has trained them on who their contact person is, who their
Mhm.
Title IX coordinator
And
is.
they don't have a landing page on their website that prominently displays who the Title IX coordinator is, and it's not filled in on their board policy, manual on their website. And that's where we run into issues. One of the most interesting resolution agreements that I've read lately said, I mean, it was a whole paragraphs long analysis of nobody knew who the Title IX coordinator was and what to do with a sexual harassment complaint. They had the training, but no one took it very seriously.
Nah.
Ah! And if you see staff are completing their what should be 30-minute training in 3 minutes, you probably ought to be doing something about that.
Yes, yes, indeed. Yes, indeed. So yeah, the training is going to be a big part of what next steps are,
Mhm.
recognizing that the training requirements have expanded to all staff and have changed for your Title IX personnel in different ways. So, be on the lookout for more from us. I'm sure you're getting inundated with all sorts of things about Title IX training.
Yeah.
But there's a reason for that, and it is important. So
Yeah.
please pay attention to that. Any other thoughts on training, Ellen, before I let you tell us about some of the fun things that are in the rules themselves?
I don't think so. I'm ready to move on unless we have any more. I don't see any more Q&As. Okay.
All right.
So I think I've already mentioned part of this. Our process is going to be substantially less. No more 2 school business day response periods and then an appeal period that lasts another 10 school business days, plus a 5-day opportunity to submit a written statement and a 30-day appellate decision maker decision. This is going to be far more streamlined. It is not going to be totally in line with how you handle a normal student disciplinary matter, but I think we're a whole lot closer. We're going to work with IASB continuing to develop procedures that are best for K-12 schools. And now that the Department of Ed has given us the flexibility to do so, I think they acknowledge that those rules weren't great for K-12 schools. They were really, as I've said before, and I think Brandon, as you've said before, those were written for colleges and universities. They weren't written for our issues here.
Right.
Something I've noticed in the resolution agreements that I've been reading is that OCR has been putting a lot of focus on remedies to complainants, making them whole again, particularly for students with disabilities. If students with disabilities are harmed amidst a sexual harassment complaint, that we are looking back as to whether they need compensatory services. I've seen in quite a few resolution agreements. Anything you want to add, Brandon, about that?
No, I mean, I think that's exactly what's there, and there have been a number of those, and we really see the Department of Ed and OCR, I would say especially over the last year, saying, no more grace. It's time to get this right.
Yeah,
I
yeah.
think that's the message on these new rules, which is we're
Mhm.
giving you some flexibility in terms of process, so you need to get the process right.
Mhm.
And I think the part that makes that going to be a little bit more of a challenge for us is the fact that they've also broadened the scope.
Yeah, the scope is much broader. We are encompassing all sorts of conduct now. We have gender harassment, we have sexual orientation, gender identity, we have pregnancy. This is more than just sexual harassment that is quid pro quo, severe, pervasive, objectively offensive, or those big four crimes. So like I mentioned, we've got sex stereotypes, we've got sex characteristics, pregnancy, sexual orientation, gender identity. There was question under the prior rules that I think the Biden administration did attempt to make more clear through an executive order, but I don't know that we ever officially got there because the rules said what the rules said. But it is clear, it is without question now that if you are hearing about discrimination on any of these bases, you are under your Title IX grievance procedures. And then we still have those sex-based harassment issues. We have the quid pro quo, the hostile environment sexual harassment, and we have a whole new definition for what that is. We don't have the severe, pervasive, and objectively offensive definition anymore. We have a new one. It's a severe or pervasive. We still have sexual assault, which encompasses fondling, it encompasses rape, it encompasses other sex crimes, and then we have our dating violence and stalking still.
So here's that new definition of that hostile environment.
Yeah, so we went from what was fondly called SPOO, and it kind of gave me the to we now have unwelcome sex-based conduct that based on the totality of the circumstances is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from the recipient's education program or activity. We no longer have to effectively deny it. It can just limit it, and that is enough. And there were a lot of questions under the prior rules of what on the basis of sex meant. Was it enough that it was just a that it involved a private body part, or did we have to have an intention of sexual or romantic conduct? You know, there were different positions taken on that issue, and I think it is without a question now that even if there is no romantic interest, that if it is intentional conduct with a sexual body part, that is enough to put us in the purview of Title IX.
I agree. So the grievance process is now going to be expanded to some other things. So tell us about that.
Yeah, we have disparate treatment now. So when someone is alleged to have received different treatment on the basis of sex, we have disparate impact where we have a neutral policy, but it has an impact on people of one sex more than the other. And we have retaliation that now has to flow through our Title IX sex discrimination process. That no longer can be pushed into our other process. We had advised under the prior rules that go ahead and push those to your 2260 process because A, it's faster, and B, there's no need for us to go through that whole process. Exchanging information, a investigation report, all of the abilities to prolong the process. Now we're going to be within our process, but like we've mentioned, that process is going to be so much shorter.
We also see our jurisdiction expanding.
Yeah.
It may not be the part we're the most excited about, but I think this does actually line up more plainly with how we handle other student discipline matters.
Yeah, I think so too. And I think it lines up with what OCR has been telling us, not necessarily with what people have been doing. So anytime that the respondent is subject to recipient's disciplinary authority, that is a time when Title IX applies. So if you guys have policies that regulate lots of conduct for your students, even outside conduct, you may have some obligation for conduct that you would not ordinarily want to have jurisdiction over under these rules. And in addition to, and this is something I think we've advised and most of our districts want to do anyway, is whenever there is conduct that occurs outside of the school district, but there is an impact at school. So, you know, you have a student who experiences a sexual assault outside of school and has to come back to school and live in that same building with the other student all day long. You know, you want to do something about that so that the student can continue receiving an education. There is no question that you are required to do so now.
Yeah, and I think, you know, when the Supreme Court sort of not expanded, but clarified, you know, our ability to discipline off-campus social media conduct when it constitutes severe bullying and harassment targeting students, that's now going to be true for sexual harassment that's happening via social media when it meets that standard, if we would treat other conduct the same way. Now, I realize that this change is probably gonna have a bigger effect in other states. In Illinois, we already have state law that impacts this, but I do think part of why we've seen some legal challenges filed by other states to these rules relates to some of the gender identity stuff.
Yeah, that a recipient can't separate or treat any person differently based on sex that subjects them to more than de minimis harm. And that has been outlined to de minimis harm has been outlined to mean not allowing a person into a locker room or a bathroom that is consistent with their gender identity. Really wasn't an issue for us here in the Seventh Circuit for quite some time, but certainly an issue in other states.
And then those supportive measures.
Yeah, I think they're pretty consistent with what we saw before. They can't unreasonably burden either party. They can minimally burden either party. They can't be imposed for punitive or disciplinary reasons. But now we have some rules that they have to have the ability to challenge a decision to provide, to deny, to modify, or terminate supportive measures applicable to that party. Something that I've been working with school districts on recently as they implement supportive measures is putting an end date on things. We have a lot of things that have just sort of been implemented indefinitely with no end term. I like an end date on this. And now we clearly have the ability to challenge the end of those. I think you're even safer now to do so. These are for the purpose of restoring or preserving access. And I think they're a great way to protect your educational environment as a whole. I love educational conversations. I'm a huge proponent of those. I even have a template if you ever are feeling like you want to work on your educational conversation having with your students. I'm happy to provide that template to you. But I think it's a great time to sit down with a student, say, here is what is expected of you. Here is what is alleged. You don't have to respond. You don't have to tell me anything. You're not in trouble. But what I'm hearing is something that really concerns me. And for us to be able to ensure that every student is safe and is healthy here at school, it's important for us to ensure that whatever is happening does not continue. Can you comply with that? And I think whenever you have done that and you have a record of having done that, you've done something. You've met your obligations under state law. And you've also set yourself up for success on the back end if the respondent repeats that conduct, that it is now even more severe because they had absolute knowledge that they should not have been doing that. I also think an underutilized supportive measure is school-wide messaging and assemblies. I think those are both great ways to get the message out there that this is unacceptable in our school environment. If you are hearing complaint after complaint, report after report, it might be time to consider some school-wide messaging.
And that's something that OCR has certainly emphasized in many resolution agreements that we've seen as well.
Absolutely.
So tell us, Ellen, what's different about the informal resolution process than under the 2020 rules?
Yeah, I think you can get there quicker. You don't have to have a formal complaint to get there. You can start there, which was something that was really inconvenient under the prior rules because you would have to have a formal complaint filed. That formal complaint would have to be noticed to both parties, so they get written notice that a complaint has been filed. Under these rules, you can move straight to informal resolution. Now, there's going to be some amount of notice that has to happen, but under these rules, notice can even be verbal. Verbal notice is enough of these allegations. And, whenever we're noticing an employee, I would discourage verbal notice. But when we're noticing a student for, sort of minimal conduct, I think this is a great route to go, and to go early and to go quickly. Your informal resolution facilitator may not be the investigator or the decision maker. That's important to know under these rules, that person needs to be separate. But the decision maker can be the Title IX coordinator and the investigator. So you're going to want some person to be the informal resolution facilitator who's a little bit outside of the Title IX process if it were to go to formal complaint. For employee on student conduct, we still can't use informal resolution. That hasn't changed, and that makes sense. There's a different a power imbalance between an employee and a student. Here's what I love about these rules. A single investigator model is an option. The person who does the investigation can also be the decision maker, which was not an option under the prior rules, and that didn't make sense for our K-12 schools. The person who investigates the conduct is oftentimes best suited to make a credibility determination about who was being dishonest whenever they were in the investigation process. And they're most familiar with all of the evidence that has been collected. So I'm a fan of the single investigator model, particularly for our small school districts. I think this is a win, and I think that districts should really consider this. There are some circumstances where it does not make sense, and where you might be best to separate that position out, particularly with student on employee complaints. I think that might be a better place to separate.
Yeah, I think that's, obviously one of the biggest changes here, other than the timelines, is that ability to have your decision maker also be the Title IX coordinator or the investigator. And that I think is going to also streamline that process as well. But I don't think that means we need to train fewer people.
No, better to have lots of people trained. So a complaint can be oral or written.
Yeah, and I think as we jump into this is also a place that I think is a big
This is a
difference,
huge
and we've got to have our radar up.
big time.
Because there's no magic words.
Yes, I like that. There's no magic words for this one. If they're making a request to you that can be objectively understood, that they're asking you to do something about it, it's a Title IX complaint. You can ask them to reduce it to writing. You can reduce it to writing yourself and ensure that is clear. Put that in front of them and say, is this what you're saying? And this is true whenever you hear an athletics complaint, whenever you receive a letter that says you are out of compliance, you are providing more benefits to your male students. This is true for gender identity harassment. When your LGBTQ students are saying someone is bullying me, we might be both under our bullying policy and our Title IX policy. Pregnancy discrimination, still our sex-based harassment, and our sexual assault claims.
Yeah, I think that we definitely, I think that's part of the key pieces in training, and especially for all staff, is realizing that somebody doesn't have to use the magic words Title IX or sexual harassment or sex-based discrimination in order to make a complaint, and the fact that we have an obligation to respond in a prompt and effective way to an oral or written complaint means we're going to have to really understand what those obligations are and be ready to interpret and implement.
Yep. Okay.
So the process itself is streamlined,
Yeah.
mostly because we're taking out those 10-day waiting periods, but what else is going on differently in those rules?
Yeah, so we still have the presumption of non-responsibility. We have a new requirement that we need to take reasonable steps to protect the privacy of parties and witnesses. This doesn't mean that they have the right to be anonymous, neither the parties nor the witnesses. Everyone has a right to be informed so that due process can occur, but you have to take steps to prevent the parties from sharing out information that they only receive through the grievance process. Now, if they knew this information outside of the grievance process, kind of fair game. But if they received this only through the grievance process and you find out that they've shared it, you do have some obligations to end that and to remedy that. We're going to have reasonably prompt timeframes for all major stages instead of this larger 90 school business day process. Those are going to be cut down and broken down into steps. I know that was something that school administrators often asked me. They may have asked you the same thing, Brandon, of how long do I have to do this? How long do I have to do this? And it was like, you have 90 days to get all of this done. So hopefully everyone likes that a little bit better.
Yeah, and I think that privacy piece is important because the 2020 rules said we were prohibited from putting a gag order in place. Now we're almost required to put a gag order in place.
Yeah,
so definitely a change from the prior rules.
For sure.
Other
There are no
changes.
longer mandatory dismissals. There used to be mandatory dismissals. If it did not meet the standard, you were required to dismiss. Now the Title IX coordinator has, I believe, I think it's a 6-factor analysis to move through as to whether a complaint should be dismissed. A lot of the factors are similar or the same as those that were considered for both permissive and mandatory dismissals under the prior rules. So it's not a massive change, but it is a little bit of a change. We're not automatically kicking things out. The burden on the recipient to gather the information, that's the exact same as before. You can't say, well, because She didn't tell me about it and she didn't provide me with it. I had no idea that it existed. You do have some obligation to ask for things, to seek things out yourself. Equal opportunity to present fact witnesses, other inculpatory and exculpatory evidence, same as before, and access to evidence is changed just slightly. So under the prior rules, you had to share all evidence. You had the 10 school business days, and then you had the investigation report and another 10 school business days. That's changed under these rules. So under these rules, you have the requirement either to share everything or to provide an accurate description of all of the evidence, and then the parties can ask if they want to see it. I think I'm probably a fan at this stage of just go ahead and share everything instead of dealing with the time burden of someone requesting it on the, we don't know how long those days are going to be written into policy yet, but on the, if there's 5 days and they wait until the 5th day to ask for it, now you're probably required to give them some time to go through it. I think share everything at the front end, give them that time and move forward with your decision thereafter. I think it also takes the administrative burden of creating an investigation report, or at least lessens that. I don't think you're required to do that.
Yeah, I think that's exactly right. And I think that that's, again, part of that streamlining piece. And then the decision maker.
So I think this is a huge bonus for the single investigator model. If your decision maker is the investigator, you've already completed this step that you have to ask, or you have to have the ability to ask parties and witnesses questions to determine their credibility. If you've already done that because you were the investigator and you asked all the questions, I think we avoid this additional step. I think that's a plus for the single investigator model. And, under these, when these rules were proposed, my gut reaction to a single investigator model was a little, oh, I'm not quite sure of that. As we read through these rules, I'm becoming more and more of a fan of a single investigator model.
You convinced me. I was in the same place. So you convinced me. So I
think there's some circumstances not to. I do. I still think that employee on student conduct, I think it's better to separate and some of those rules out, because I think it's really easy to start prejudging things. But in a lot of circumstances, I think these look good.
Yeah.
Now, here's what I want to say, because across the board, I see this as an issue. Make a determination in every civil rights allegation that you get, if it's race, if it's bullying, if it's gender, if it's sexual harassment, make a written determination and notify the parties that you have done so. OCR is incredibly frustrated with school administrators not doing that. And, I understand why. School administrators are good-hearted people who don't love telling people that they've done something wrong. As a conflict avoidant person myself, I can get behind that. But what OCR wants of you and why you guys make the medium bucks is because you guys are there to make a determination as to what happened. If you don't make a determination, somebody else is going to. You have the first ability to make that determination, so do so. I understand that you weren't there and that he said this and she said this and he said this and she said this and he said this and she said this, and it's easy to just write that part down, but determine who was credible and determine what happened.
Absolutely. And then the other piece to it that's not really changed is that we can't discipline until that process is complete.
And everybody gets an advisor to the extent that they want one.
Yeah. So a couple other things that just to kind of compare and talk about, how that plays out.
Sure. Yeah. So for sex discrimination complaints, pretty much anyone can make one. Anyone who either was affected by it, or the Title IX coordinator, or anyone who was attempting to participate in a way and this has prevented them from participating, can make a sex discrimination complaint. If it's sexual harassment, only the person who experienced it, or the Title IX coordinator, or the person's parent, if they're a minor, can make that complaint. So for sex discrimination complaints, we have broadened the scope of who can make them.
So before we move off of Title IX, I want to first pause and see if anybody has other questions on any of that. I mean, we took a 30-minute walk through the highlights of what's changed, right? And I think that one of the things we recognize very plainly is that, enough has changed, and especially the definitional pieces. That,
Mhm.
it is going to be fundamentally different than the process that happened under the 2020 regulations.
Mhm.
And so we see more flexibility in process, but more conduct that falls under that process, and expansion and training. I think those are the main takeaways for me. Ellen, are there other main takeaways for you from that big picture perspective?
No, I think that's sort of the big picture. I'm happy to answer questions if anybody has something burning inside of them.
So as you all ponder that, I'm going to talk about some other things, and of course, Ellen is going to weigh in as she sees fit through this too. But we've had some recent Supreme Court decisions and other things out there that I think we just need to take a minute here in our last few minutes before we just open it up to questions to talk about. So I just am again going to quickly hit some of these key points and then see what questions you guys have. The first thing I have for you, though, is not a Supreme Court decision, but a reminder of a statute that's in effect this year, because this is graduation week for many of us, or it's coming soon. And maybe last August we weren't thinking about graduation when this bill became effective, like we are now. And Public Act 103-463 does put limitations on our ability to limit what students can wear to graduation, and that we cannot prohibit the right of a student to wear or accessorize their graduation attire with items that are associated with the student's cultural, ethnic, or religious identity, or any other protected characteristic or category under the Human Rights Act. And again, while we can still restrict messages or items that may be materially or substantially disruptive, or that are lewd or vulgar, we can't, restrict based upon any of those protected characteristics, which we know include, among other things, disability, gender identity, sexual orientation, race, any of those protected categories. So make sure that as you all are getting ready to enjoy your graduation exercises, that you're not stepping into this piece where you've overlooked that law that changed last year. Okay, now let's talk about the Supreme Court. Supreme Court, we got a lot of cases left to go over the next month, right, from the Supreme Court. I mean, it is that time of the year now. I think they've finished hearing cases. Now they're just deciding them for this term. And we're likely to get Supreme Court decisions rolling out probably weekly at this point through the end of June. I think last year they went into July to finish up their term. But there are a few of them that I think have particular impact on school districts that we need to be thinking about. The first one is Lienke versus Freed. This was decided in March. And this comes back to really impacting your social media, right? And the First Amendment implications of, as a school official, when is your social media your personal social media, and when does it transform into an official social media for purposes of the First Amendment and other considerations for us. So this is not a school case. This involves somebody who was the city manager of Port Huron, Michigan. But I think we can easily see, and we will see a companion case to this where that, could be a school administrator, right? A superintendent, a principal, someone in that regard. And, he had a public Facebook profile, so anybody could see his posts. He posted what I would say are sometimes mixed use here, right? He posted personal things about his kids and his personal life, but he also sometimes highlighted things from the city, posting things about the city that city residents sometimes inquired about and commented on in ways that they thought might be, related to city business. And of course, during COVID, some people didn't like the posts, wanted to criticize, and he ultimately blocked or deleted some comments that he didn't like from a community member, Kevin Lienke. And of course, Lienke said that violates my First Amendment free speech rights. You're the government. You deleted or blocked my comments. And this case goes to the Supreme Court. And the Supreme Court said, look, there is the possibility here for a public official through social media to violate those First Amendment rights, and perhaps even give rise to an action here if, and this is the standard, right, that person possessed actual authority to speak on the government's behalf and purported to exercise that authority through the social media posts, right? And then said, now go back and re-decide that case. And they said, look, and again, this was a unanimous court, Justice Amy Coney Barrett writing for the unanimous court saying, you can't automatically insulate it by saying that it's a personal page, right? That if in fact you are using it for mixed purposes, where there is both personal and government related content, then we're going to have to look at the post's content and function, right? So it really is, kind of out there. When you say it's my personal Facebook page, but then you post something and they're hypothetical, pursuant to municipal ordinance 22.1, I'm temporarily suspending enforcement of alternate side parking rules. Well, that starts to sound not like a personal Facebook page, but an official one. And I wonder in the school context, right? If that's where we're announcing things like, we're not going to have school today because of snow or whatever else, when are we crossing that threshold? And the Supreme Court said we will look to custom or usage, right? As part of that. The other case that was decided concurrently with that was O'Connor Radcliffe versus Garnier. This was a case out of the Ninth Circuit that involved school board members. So same basic idea. Here you had school board members who had a public Twitter page who were blocking or deleting comments from others. And the question was, were these, once they were elected, official accounts, or were they their personal accounts? And here the Supreme Court said, look, this is because we decided, Lueking versus Freed, you need to go back and remand this. So they vacated the Ninth Circuit and went back. So again, we can see the Supreme Court here and, what is definitely a school case applying that in the same way. So I think it is very important for us to, keep that in mind and be mindful of when and how our personal social media accounts might, in customer usage, look like an official account. Thoughts or anything on that one, Ellen?
None, but we did get a Q&A question if you want me to read it to you.
Please.
What if the district says no decorating graduation caps, then someone decorates their cap depicting their cultural ethnic background? Can we say no decorating caps, but feel free to wear something another way?
The statute's very broad, and I'm going to go back to the language of the statute, right? So I'm going to scroll back here. That says that we cannot prohibit the student's right to wear or accessorize their graduation attire. Now, I think under the First Amendment, we have time, place, and manner. So we could say you can't do X, but you could do Y. But this is written more broadly than that. Yeah. And I think the answer is no. I would not restrict. You cannot prohibit the right to wear or accessorize the graduation attire. I don't think there's any limitation on that beyond what's in the statute. Okay. So let's talk about a couple other cases here. The next Supreme Court decision, which I think could have an impact on school districts that we've got to be aware of, is a case decided here in late April, another Supreme Court decision, Muldrow versus the city of St. Louis. So again, this is not directly a school case. This involves a police officer who was transferred. And so the question is, what is the standard for what might constitute discrimination under Title VII of the Civil Rights Act? And so, the issue here is how significant must that conduct be? And so this case involves a police officer who was transferred to another position. That transfer did not involve a loss of pay or benefits, but it did have some more what you might call intangible changes, right? Instead of being a plainclothes police officer, she had to wear a uniform now and slightly different, maybe, while again, same rank, same pay, same benefits, maybe it wasn't as prestigious, other things that were sort of at at the edges of the position. And so the question is, how much harm must an employee suffer? Is a transfer enough potentially? And the Supreme Court said, yeah. Justice Kagan wrote the opinion, said that, there is no requirement under Title VII to have a threshold of significant harm or serious harm, so long as there is, quote, some harm. And so we definitely see this being a lower threshold. So I
Yeah.
do think as we think in the school setting, it is very common this time of year, we're thinking about transfers, right? Giving notice of assignments letters for next year. And so has the Supreme Court opened the door for, teachers who get transferred from third grade to fourth grade, from kindergarten to sixth grade, whatever? Does that open the door for a discrimination claim? And I think the answer is it might, and so I think those are things where we recognize the Supreme Court has opened the door, and we need to therefore have good documentation, good reasons, legitimate non-discriminatory reasons for why we're taking the actions that we're taking in order to overcome those complaints.
Yeah.
Now, let's go from the Supreme Court to the Southern District of Indiana. Although I still think, Ellen, this case is going to eventually end up in the Supreme Court. It just has to get there. It's been back and forth to the Seventh Circuit twice now.
It's taking its time. It's
It is
winding.
definitely taking its time getting there. This case, the Cluj case, involves a high school teacher who said that based upon his sincerely held religious beliefs, that he could not refer to transgender students by their affirmed name and pronouns. And ultimately that resulted in his resignation. And he sued, claiming that that violated his right to religious liberty and that the school district should have granted him a religious accommodation that said that he did not have to use students' affirmed name and pronouns. Just kind of the history of this case, if you're aware, the Southern District of Indiana found in the school's favor. The employee appealed that to the Seventh Circuit. The Seventh Circuit affirmed that, found in the school's favor again, saying that it would have, substantially burdened the operation of the district, have granted that an accommodation. But then after the Supreme Court's decision last year in Groff versus DeJoy said, we've got to go back and have a do-over in the lower court because the Supreme Court last year again changed the standard for religious accommodations under Title VII. And so it looked again to whether that is a substantial impact for that. And so it got remanded back. And here just a few weeks ago, we got that decision where the district court once again issued an order again in favor of the school, finding that sufficient undue hardship existed in the context of the school's business, finding that a religious accommodation that actually resulted in substantial student harm and an unreasonable risk of liability, and that it was in contradiction to the school's mission to foster a supportive environment for all students. Not seen an appeal again to the Seventh Circuit, but I anticipate that one is coming. That timeline is still there. So
I think there's 10 days. Yeah, I think there's 10 days left.
All right. Well,
we'll see.
We'll anxiously wait to see if this is the end of that case or the beginning of the next chapter of that case. But we've been watching that one for a while for us. And then the other case I want to mention briefly here and then open it up to whatever questions. The Fourth Circuit just on May 15th, so just late last week, affirmed a lower court decision in the case of McMood versus McKnight. And that case involved the Montgomery County, Maryland School District, where parents were seeking the right to opt their kids out of certain books in the curriculum because those books included LGBTQ characters. Now, again, absent the automatic opt-outs under state law, like dissection of animals and sex ed, there's no automatic religious right for parents to opt out of the curriculum unless they can show that it would constitute indoctrination. In this case, the lower court said that this did not, meet that standard of indoctrination and was a long way from it. And again, noted that every court that has addressed the question has concluded that the mere exposure in public school to ideas that contradict the religious beliefs does not burden the religious exercise of students or parents. And again, the Fourth Circuit just affirmed that last week. Probably this one's going to be appealed to the Supreme Court. Plaintiffs have indicated that. But again, looking at what was noted here in the decision, again, citing an older 30-year-old, Seventh Circuit case, the Fleischfresher case, saying that exposure to ideas that go against the religious beliefs of students or parents are not a free exercise religion because the curriculum at school does not preclude them from meeting their religious obligation to instruct their kids at home. And quoting back to the Supreme Court decision back in McCollum, right? If you remember, McCollum versus Board of Ed is is here locally, right? That's the Champaign School District prayer case from the 1940s, so these are cases going back to that point, saying again, if we were to eliminate everything that's objectionable to any religious group, we would leave public schools in treads, and that the reading of a teacher by one book or even three, even to a young and impressionable child, does not constitute indoctrination. And again, the Fourth Circuit noted in its decision last week, there was no evidence in the record that connects the requisite dots, right? To know whether that would be any burden on their religious belief and activity, and so they said that they can't reach that conclusion now. So again, I think we see consistency in the case law on that issue about opt-outs, but we'll see what the Supreme Court has to say about that, I suspect, at some point.
Yeah.
So I see at least one question here. So we've got a few minutes here left for questions. So if you guys have questions, please don't be shy about asking them. I'm
hearing school districts discussing choosing not to follow the new Title IX regs. Are there potential consequences for this beyond losing federal revenue? I mean, I would say that I think they're also consistent with state law, so you're subjecting yourself to litigation, both under state and federal law.
That's right, because remember, it's not just a matter of not getting funding. Parents can and students can bring claims under Title IX, right?
For the right of action.
There is a private right of action where I mean, there was a jury award that was just affirmed out of the state of Washington, where the failure to follow the Title IX procedures resulted in a $500,000 jury award plus $1 million in attorney's fees, right? So, there's certainly a private right of action that exists. The Supreme Court has articulated that. Now, the standard is different than OCR enforcement, right, for that private right of action. But I think an intentional decision not to follow those rules aren't going to get you there. Now, my guess is that when we're talking about not following the new regs, it's not the sexual harassment piece, it's the LGBTQ piece, which again is already the law in Illinois. So in other states, I think there may be different potential consequences beyond that private right of action. In Illinois, I think that's very, very plainly, clearly covered by state law, as well as the Seventh Circuit's current precedent. Well, any other questions before we wrap things up this afternoon? I'm glad so many of you could join us. I know it's May. I know it's a crazy time of the year, and you're trying to wind down, and you're like, why are these lawyers putting more on my list? But it's because that stuff's on our list too. And we want to make sure that you get to share in the wealth of all of this exciting pieces. The preamble to Title IX regs is, well over 1,500 pages long. And I think we estimated if we read 50 pages a day, it would take us a month. I'm almost there, right? I'm almost there. To be able to see everything that's in those regulations. So make sure that stuff's on your radar as you wind things down. But thanks for everything you're doing for kids this time of year. And as you're making your summer to-do list, don't forget your Title IX training, your changes to policy that are there, and all the other things that are out there. Oh, I do have one other thing I'll leave you this question to answer, Ellen, before we end. It's also handbook season. And of course, we won't have our press procedures for the new rules until likely right at August 1st, I anticipate. So, we've got to make sure that as we're preparing handbooks, that we're going to have to be ready for these changes as well.
Yeah, I think there's two ways to do that. I think you can either reference that an addendum to the handbook is going to come with your new Title IX policy and procedures. I think you can also just reference it that it's going to still be 2265 and the accompanying administrative procedures.
Well, thanks everybody for joining. We appreciate the hour of your time today, and happy end of the school year, and we'll talk to you all soon.
Thanks for being with us.